I would just first like a little bit of clarification from our reviser about whether tomorrow is the last day for request for introduction for committee bills in this committee. If we could have just some clarification on that, and I think we have Ms. Jenna Moyer from the reviser's office with us this morning.
Good morning, Madam Chair. And tomorrow is not the last day for request for introduction in this committee. Oh, I hear some echo. That would have actually been Monday. Tomorrow is the last day for our office to actually turn those bills in to the chamber.
There we go. Okay, because yes, we had been talking that Monday, February 8th was the last day, so we were correct on that then. So thank you very much. So then, committee, we will turn to the hearing on Senate Bill 123, and we will open the hearing on Senate Bill 123. And with that, back to you, Ms. Moyer from the reviser's office for a bill brief.
Thank you, Madam Chair. Good morning, committee. This brief will be on Senate Bill 123, which creates a process to terminate the parental rights of a person whose sexual assault of another has resulted in a child being conceived. And sections 1 through 7, you'll see in this bill, are all new sections of law. And section 1 defines terms that are used in the act. Section 2 would allow a petitioner to bring an action to terminate parental rights of someone, of a respondent, when a child has been conceived as a result of an act of either rape, aggravated indecent liberties, or incest, even if a conviction has not occurred. Subsections B through G outline the procedures related to filing pleadings, the contents required in a petition, venue, jurisdiction, and service of process. Section 3 makes court records of proceeding under this act confidential and exempt from disclosure under the Open Records Act, and would also allow a court to exclude any person from those proceedings if it is in the best interests of the child. Section 4 begins on page 4, line 21, and it specifies that a respondent under this act would be entitled to be represented by an attorney in the proceedings, and allows the court to appoint an attorney for the respondent as well as a guardian ad litem for the child. Section 5 gives the court authority to enter a temporary order restraining a respondent from following, contacting, or communicating with either the petitioner or the child during the pendency of these actions. Section 6 provides that if the respondent is determined to be the parent, the court may terminate the parent-child relationship if the court finds, by the burden of clear and convincing evidence, 3 things. And the first is that the respondent committed the act of either rape, aggravated indecent liberties, or incest against the petitioner. 2, the child was conceived as a result of this act. And 3, that termination of parental rights would be in the best interests of the child. Then the bill creates a rebuttable presumption that terminating the parental rights of a parent who committed such act of sexual assault is in the child's best interests. Section 7 relates to the rights of parents and children under this act. Subsection A would allow a child to retain the right of inheritance from a parent who has had their rights terminated under this act. And subsection B provides that a respondent who has had their parental rights terminated shall not retain any rights to legal custody, residency, parenting time, inheritance from the child, or standing in any adoption, potential adoption of the child. Subsection C sets out that termination of parental rights under this act would not receive a respondent. So one of those parents who may have had their parental rights terminated would still be obligated to pay child support unless waived by the petitioner and approved by the court. And before ordering child support, the court would need to determine that such an order is in the best interest of the child. And this final part of this section sets out procedures for payment of the child support. Section 8 amends KSA 233203, and these are the factors that a court considers when determining legal custody, residency, and parenting time of child. And this would just add the factor of evidence of a sexual assault, which is on page 7, line 41 to those factors. Section 9 amends KSA 382269, and as such, it sets out the factors that a court would consider when terminating parental rights. Current law provides that a finding of unfitness can be made if there is a conviction of a felony in which sexual intercourse occurred and a child is conceived. And this bill would change that conviction requirement to a requirement by a court finding by clear and convincing evidence that a parent has committed an act of either rape, aggravated indecent liberties, or incest, which has resulted in a child being conceived. Section 10 amends 3822-71, and this statute allows a parent to be presumed unfit if certain conduct or conditions are proven. And this conduct or condition must be proven by clear and convincing evidence to create the presumption of unfitness. Current law requires a conviction of rape that resulted in conception of a child, which this bill amends, showing that a parent has committed one of those acts of rape, aggravated indecent liberties, or incest that resulted in a child being conceived as a type of conduct that would create a presumption that that parent is unfit. And that's a lot all at once, but I'll be happy to answer any questions over this bill.
Thank you, Ms. Moyer. Questions for the reviser, Senator Pyle.
Thank you, Madam Chair. I think I heard you say that, and I want clarification, I want to make sure absolutely clear on this. So with termination of the parental rights, would the child support obligation still remain?
Yes.
The presumption is that yes, it would remain unless it is waived by the petitioner and approved by the court.
Okay, if it's not waived, I guess my question is, without parental rights, could that guilty person still have any avenue of access to that child?
So I can see why you're asking the question, because usually when parental rights are terminated, child support rights are also terminated, and this would be a little bit of an exception to that rule. But the payment of child support under this bill, when the parental rights are terminated, there would be still no access or no legal rights to legal custody, residency, or parenting time.
Okay, Madam Chair, if I can, one more little, I just want to be clear, for the severability of the parental rights, it does require conviction.
Ms. Moyer?
No.
No.
It requires a finding by clear and convincing evidence under this bill in this circumstance.
So it's up to the courts. Then it'd be up to the courts.
Yes, yeah, and that finding by clear and convincing evidence, it's somewhere in between, that finding of beyond a reasonable doubt and the more likely than not that's used in civil cases. And this clear and convincing evidence is what is used generally in those termination of parental rights statutes. So it's a higher burden, but it's still less than the burden required to be proved in a criminal case.
Thank you, Madam Chair.
Thank you,
Senator Thompson, sorry.
Thank you, Madam Chair. We heard this bill, I think, last year. I just wonder if there were any substantial changes, or it's exactly the same as it was as presented last year, because I too was troubled last year by not requiring a conviction and the clear and convincing evidence thresholds. I understand we're dealing with most of these people are not nice people. But the one exception that might be somebody that, you're taking away parental rights and they may be innocent. And so I just wondered if this is the same bill that we heard last year.
Yep, Madam Chair, I can answer that. And this is the same bill that would have passed the committee of the whole. I think there was a typo that we fixed in a floor amendment at that time. And so it would be the same as last year. It was Senate Bill 404. And it passed the Senate, let's see, by a vote of 40-0, and then ran out of time in the House.
Thank you, Madam Chair. Thank you, Jenna.
Thank you, Ms. Moyer. I had a question regarding who's allowed in the courtroom for these types of hearings. It said, I don't recall which section, it said the parties attorneys, and I don't recall who else, but witnesses would be allowed to appear. Is that correct?
I was just finding the right section. There's nothing in the bill that would exclude witnesses, just that the court has that ultimate discretion. If someone were to be there that would not be in the child's best interest, that they could exclude them from those hearings. But there's nothing in the bill that would prohibit, the attorneys being there, the witness, the judge, any sort of necessary parties to the pendency of those proceedings.
Including witnesses who aren't parties but would need to be heard from regarding whether there's clear and convincing evidence of the bad behavior.
I mean, generally, the witnesses would be allowed, although there is also motions to exclude witnesses, except for their testimony, which would be up to the parties in those motions before the judge, but it's not addressed in the bill. That would be probably just more the civil procedures that would govern that.
Right, and up to the judge's discretion then, because this procedure is under our civil code, chapter 60, not under the criminal code, correct? Yes. So are there any other questions for the revisor from the committee? All right, seeing none then. Thank you, Ms. Moyer, and we will have our first proponent conferee, Gillian Chadwick with the Kansas Judicial Council, who I believe is appearing on WebEx. So if you'll please introduce yourself and welcome to committee.
Thank you very much. Can you hear me?
Yes, we can.
Great. My name is Professor Gillian Chadwick. I am a faculty member at Washburn University School of Law, where I teach in the law clinic, and I also am the Associate Director of the Children and Family Law Center. And today I'm here on behalf of the Kansas Judicial Council. I'm a member of the Family Law Advisory Committee of the Kansas Judicial Council, and we have been working on this issue and this bill. I was just looking back through my notes at least since 2017. So thank you very much for the opportunity to testify today. Thank you for accommodating me by WebEx, and I'm happy to talk a little bit about the bill and answer questions. So as mentioned, I'm here in support of the bill. The Family Law Committee worked on this bill, and again, it was introduced last year and it was passed unanimously after a technical correction. And so what I want to stress today is really that the purpose of the bill is to address the needs of survivors of sexual violence who would otherwise be forced to co-parent with their rapist. And so we decided in the committee to address this through 3 different means, which were just very well explained. And those are that there's a independent action for termination of parental rights. There is a clarification in the child custody laws, and there is I guess, expansion or clarification in the child in need of care laws. And the reason that we decided to approach this problem with a 3-prong solution is because we wanted to give survivors different options and allow them, depending on where they are in the court process, to be able to either respond to a rapist who is trying to acquire or exert parental rights, or to affirmatively, through the independent action, go ahead and take that step to terminate parental rights without having to open the door to a custody case. We've looked at a number of other states. There are 44 states in the District of Columbia that address the issue of rapist parents pursuing custody and visitation. There are 25 states and DC that address this through termination. And there are 18 states that have a general prohibition on custody and visitation rights for a rapist. So we are, not really the most extreme on either side, kind of right in the norm with what we're proposing. And again, the problem here is that currently under Kansas law, survivors of sexual violence have no protection to keep them from having to co-parent with their rapist. So like everyone else, they have to go through the standard procedure. And so this law would really provide relief to what we think is ultimately a small number of people who conceive through rape and then decide to parent the child. But those folks are really, really suffering. And so we're, enthusiastically asking for this bill to pass because it's an incredibly necessary change to our law. And I just wanted to address a couple of things that I was planning on speaking about anyway, but that were raised by some of the senators' questions. The question of conviction versus clear and convincing evidence. Of course, at a Supreme Court level, clear and convincing evidence is the standard for termination of parental rights. And it's considered the most heightened civil standard. And the reason, of course, is because parental rights are fundamental rights. They're incredibly important, and we wouldn't want to jeopardize someone's access to their child through a lower standard like preponderance of the evidence. There are people who believe that's the correct standard for these types of cases, but the Supreme Court has been clear that clear and convincing is the appropriate standard for termination of parental rights, and it is a very high standard. And of course, the question about witnesses is exactly right, Senator Warren. There would be witnesses. There would have to be witnesses. There would have to be evidence showing that this occurred, and so, of course, sometimes witnesses don't sit in the courtroom during a proceeding because then they can just listen to what everyone else says and offer kind of self-serving or sort of testimony that's less reliable. But so they may sit in the hallway, but they're not going to be prevented from coming into the court unless there's some, regular rule of evidence type reason why they can't be there because, they're not relevant or something like that. So it would be a standard civil procedure type approach to witnesses, with the exception that in general, people who are there are on a need to be there basis. So people aren't just watching because they're interested in what's going on in the case or something like that. So regarding the issue of a conviction, as I think is well known, there's a real problem with getting convictions in sex offense cases for a lot of reasons. And so premising this on a conviction would really be an incredibly high standard and a miscarriage of justice, really, because, the adage that we let 10 guilty people go free for, every innocent person incarcerated, I think is really something to consider here. There are guilty people who are going free in our criminal justice system, and that's by design. And it's not a perfect system, but it's intended to be a criminal justice system. And in the family law system, we need a different approach that's more tailored to be about finding the facts and not about protecting the rights of the defendant at a higher standard. So there are some statistics in our written testimony about conviction levels and those issues. I think overall, again, this is a very much needed law. It's a multi-pronged approach. The committee's been working on it for a long time, the Family Law Committee and the Judicial Council, and we're happy to be here again this year after COVID sort of took this bill out last year by no fault of its own, and we're asking for the support of the Judiciary Committee. And I'm happy to take questions.
Thank you, Ms. Chadwick. Committee will be entertaining questions after we hear from all the proponent conferees. Thank you, Ms. Chadwick. Next, we have Sarah Rust Martin from the Kansas Coalition Against Sexual and Domestic Abuse, appearing by WebEx. If you'll please introduce yourself and welcome to committee.
Thank you, Chairwoman Warren and members of the committee. I appreciate the opportunity to be here today. I am, as Chairperson indicated, Sarah Rust Martin. I'm with the Kansas Coalition Against Sexual and Domestic Violence. We are a membership organization, and the 26 direct service advocacy programs providing support to victims of sexual assault and domestic violence across the state are our members, and I'm here on their behalf today. We support KCSTV, and our member program strongly supports the passage of Senate Bill 123. We testified on Senate Bill 404 last year in support as well. My legal colleagues I think, are explaining different legal procedural questions and issues that may have come up. And I think for me, that the experience I want to make sure this committee hears is the victim experience, the survivor experience, and the experience of the advocates who are providing these services every day to those who are suffering these kinds of consequences of the sexual violence that happens in all of our communities. So direct service programs are serving victims of rape all the time, but they are seeing, I sort of surveyed folks to find out kind of what is the status of their experiences over the last year, particularly with the pandemic, because many of the services are provided via Zoom, or they're still face-to-face, but they're not in the same room. Sometimes they are. But pregnancy is one of the most significant concerns of a rape victim following the rape. Not all rape victims report to the hospital. As you all know, few report to law enforcement. And so getting some kind of emergency contraception, etc., is not always available. And so seeing those who are suffering pregnancies, we see quite a few folks who come in at the time where they recognize that they are pregnant and then seek services to figure out what to do. And advocates are essential in terms of providing information and support. So they have to provide the information so that this person can make an informed decision. They are not there to sway a person one way or the other. But at this point, the reality is talking through the options that victims have in terms of the pregnancy is very, very difficult, because the accurate information is that this person could have legal rights as a father. And that reality shapes everything thereafter that the decisions a victim will make. Because the thought of going through with a pregnancy and then having to co-parent with the person who sexually assaulted you is unconscionable. And even in the case of adoption, which some victims will ask about and be considering, notice still may have to be provided. There still may be interaction and rights asserted in terms of trying to prevent that from happening on the part of the rapist. So we believe strongly that we can do better than this, that we do not want to limit the options that are available to victims should pregnancy occur. Our 26-member programs strongly support this legislation. We do not want to leave victims to sort of live out their lives with constant fear and intimidation by the person who assaulted them. And also, I didn't speak to the child, but I think it's really important to recognize the trauma that this can have on the part of a child as well. So thank you for listening to my comments, and I will stand for questions when it is appropriate, Madam Chairperson.
Do we have any other proponent conferees in the committee meeting room or on WebEx? Seeing and hearing none, then committee, we will open it up for questions to our conferees. Senator Thompson.
Thank you, Madam Chair. For either one, I'm just curious how many cases like this we get, or would we get per year under this new law, approximately?
If
either of you or both can answer.
Sure. This is Sarah. I'm still unmuted, so I'll go first, Gillian. If in my testimony, I provide some research statistics in the second paragraph that gives us a national account of what we see, about 25,000 to 32,000 rape-related pregnancies per year. In Kansas, I don't have the exact exact research in terms of how many we see. in surveying rape crisis advocates, I asked, is this something that you are responding to and working with? And the response was yes, frequently. So again, it's subjective and it is not valid research, but that's what I have to offer at this point.
Okay, thank you very much.
Thank you. Senator Haley.
Thank you, Madam Chair. And if this was covered by the reviser, I'm sorry I had to step out to have a conversation regarding an issue back home. I guess to either of the proponents, I guess my concern, I love the concept of this bill. And I want to say to the proponents that I'll support it. My only concern, and how do we reconcile the language that's on line 36, new section 2. And Madam Chair, if this has been discussed already, certainly tell me. My only concern with this measure is, and I read, the petitioner may bring an action at any time during the child's minority to terminate the parental rights of the respondent if the child is alleged to have been conceived as a result of the act of rape, et cetera, close quote. So I'm asking the proponents who know that we live in a real world situation where oftentimes the parents don't get along. Is it possible there should be some proximity between the allegation of rape and the conception that is within a certain period of time? And my concern is parents fall out. They're not happy with each other anymore. And the mother can say at any time during the child's minority, which is, some would say, from conception until 14 or whatever the age is, you know, you raped me, and that's why our child is here, and I'm going to terminate your, or I'm going to move to have your rights terminated. That's just something that I'm thinking of in that language. I would prefer to see some proximity to the rape or the allegation of the rape within a certain period of time, and I believe that the whole of the child's minority is potentially too much, Madam Chair.
Thank you. Yes, if either of our conferees can respond, or both.
I'm happy to address that, Gillian Chadwick, for the Judicial Council. We looked closely at that, and I think I completely understand this concern, and I practice family law. Still, my students represent folks in court who certainly don't get along with you know, their co-parents, and so I think the reason that we went in this direction is because it takes years and years to get a sex offense conviction, and so for one thing, you know, by the time there's a sex offense conviction, and then maybe someone serves their time, and the victim may be going about her life, not really, not kind of projecting into the future as to what the concern may be, or, you know, may just understand that this person's incarcerated and they're not going to get out for a while, but people get released early. Abuse escalates, you know, stalking can begin, issues like that. And so it's not always predictable to the survivor whether they're going to be faced with the possibility of having to co-parent in a meaningful, real world kind of way. And so, you know, I would just point out in response to the concern that all of this is still filtered through the best interests of the child. And so we really do depend on our family law judges, and we have wonderful judges in the state of Kansas. And so the idea is that the court is going to look at the individual situation. And I will tell you that it would be very strategically unwise for someone to bring a false allegation, because that is going to be then viewed back through the expectation that parents do get along. And when there is evidence of a false allegation, that is taken extremely seriously by judges. And so there is in many ways a disincentive for even for real victims to raise these issues. And so, I would have a concern, I think, about limiting it too much because, we have minors who become pregnant from rape, and they're just, they may have a difficult family situation. Their family situation may include, a parent who committed incest against them. I mean, the levels of trauma and harm that have to be unwound for a person to get to a point where they're even willing to speak on the issue or speak to a judge or file paperwork is not going to fit into a 2-year standard, or some kind of neat standard. So we really are depending on kind of a case-by-case analysis here. And I think that the statute is tailored to address the concern of a sort of strategically motivated false allegation.
I concur.
Thank you. And I understand the senator's concern, and do we have any information from other states? You had testified that 44 other states address this and 25 other states provide for termination under these circumstances. Do we know how often these kinds of petitions have been brought to court in the other states?
Gillian Chadwick for the Judicial Council again. I don't have that information. I apologize. I would cite the same statistics that Sarah did, which are, that we're looking at maybe 8,000 to 16,000 women nationally who become pregnant through rape. And so, Kansas is we can do the math and just kind of get a rough back of the envelope estimate based on, the population of Kansas versus the United States. But if the concern is kind of a floodgates type analysis, that is not consistent. I mean, I've looked at this issue since even just out of my own academic interest prior to when the committee started working on it. And that's just not what we see. I mean, honestly, when I talk to other victims' rights attorneys across the country, it's so incredibly risky, even for a valid survivor, to bring up abuse, that it would just be, I mean, you do hear about cases where people, kind of pull out all the stops, but that just it is not in any kind of a large number, but I don't have a statistics for you, unfortunately.
Thank you. Okay, any other questions from the committee? I do have one sort of technical question on page 5 when we're talking about when a criminal conviction did not occur. That's lines 38 through 40 on page 5. The premise of the bill is that the child was conceived under circumstances of rape, incest, or aggravated and other bad situations. Has been a problem in other states with language in 38 through 40. It doesn't require clear and convincing evidence that it was this particular child in this particular circumstance of the bad behavior. It just says, honestly, any is too much, of course, but when we're talking about public policy and what we want to do to protect, like you had said, survivors and victims, is that language kind of adequate for what we're trying to do here?
Madam Chairperson, to make sure I understand your question, are you asking about whether or not we're speaking directly to whether this respondent committed this act?
Right, regarding this particular child. And it kind of goes to kind of Senator Haley's question. This might be, a long-term relationship between the two parents, and then something has caused it to come to this point. So I'm just wondering if we can be clear enough in what we're doing in lines 38 through 40 that it's this particular child arising out of these particular bad circumstances.
Yes.
Maybe that's a question for the reviser, and maybe I'm overthinking this, but
I think I can address that, Madam Chair. Gillian Chadwick for the Judicial Council. I believe, I was just looking through the text, and I think if you read the whole sentence together, which is kind of this drawn out multi-part sentence, but if you look at part B, it's that the child was conceived as a result of the act described in subparagraph A. And so, I mean, I know we talked about this a lot and even talked about timeframes and other ways of tying it in, but I believe that the Family Law Committee was satisfied that this is close, you know, that we're talking about a child who's conceived from a sexual assault and not just a sexual assault and a child, which, as you mentioned, is also a serious problem, but maybe not the exact problem we're trying to address with this bill. So yes, I think if you read it all together, it does flow that it's the same issue, but yeah, I understand the concern.
thank you. Committee, any other questions? All right, seeing none, then we will hear from neutral conferee, Judge Marlon Wheeler from the Kansas District Judges Association, and appearing by WebEx. Please introduce yourself and welcome to committee.
Senator Warren, glad to meet you, albeit by remote means. Members of the committee, my name is Marlon Wheeler. I'm the Chief Judge of the 5th Judicial District in Kansas, which includes Lyon and Chase counties. I've been in private practice since 1977 through 1990. I was appointed as a district judge in this district in 1990 and have been Chief Judge of the district since 1997. I guess you could say I'm one of the old judges left around. We wish to make it clear on behalf of the association that we offer no opinion whatsoever on the propriety of this measure. We simply believe that that's a function left to the discretion of the legislature, but there were some operational concerns that we found when we reviewed the bill that we wanted to bring to your attention. But I'm going to depart from my written testimony for just a minute or two and make a couple extra comments here after hearing the testimony of the proponents. One of the questions that arose was dealing with the situation of where no conviction had occurred. I would remind the committee members that many sexual assaults are not prosecuted for a variety of reasons, some of which are that those sexual assaults are never reported. We also find that there are times, sadly, when prosecutions are not effective because the case was not investigated properly, or for a variety of reasons, a jury just made an unusual determination. So requiring the actual event of a conviction before the possibility of termination could arise is not something that we would suggest take place. In fact, our view would be that if we really wish to make this process an effective process, you might want to consider adding a provision to this bill requiring our prosecutors and law enforcement officials to give notice of the possibility of this event taking place or this type of case taking place to a particular victim. Now, with those comments in mind, we initially in our testimony brought to your attention, as Senator Haley already did, the possibility of something of a shorter statute of limitations on bringing the actions. We have significant concerns about the possibility of harmful psychological effects on a child by inordinate delay, or for lack of a better reason, staleness of the evidence taking place. And I can't think of anything more difficult to deal with in a case of this type as a victim who has a valid case, but has for some reason a difficulty presenting that case because people have disappeared, memories have faded, or other evidence has been lost for whatever reason. I think the bottom line is that decision is one for the wisdom of the committee and the legislature as a whole. We just asked to bring it to your attention. In our testimony, we identified 4 other issues that I would call operational issues, 3 of which we have discussed at length with Ms. Laura Nordgren, who is staff counsel to the Judicial Council's Family Law Advisory Group. And I received this morning some suggestions for possible changes. I would be happy to discuss the details of these issues with you, but would simply suggest that perhaps the committee wait to work the bill for just a day or 2 until our respective groups can confer. I think we will have some jointly approved amendments to the bill that would satisfy everyone's concern. The only other issue that we see outstanding is the question of the cost of providing counsel and the guardian ad litem services in a case of this type. That duty would largely fall on our counties that provide us the funds for appointed counsel services in child in need of care and misdemeanor cases. But this being an entirely new obligation, I know of no district or county which I'm aware of that has had the opportunity to even think about this, let alone budget for the expense. The cost of the representation is going to depend upon a lot of circumstances, including the respondent's actions, but a really close parallel to this type of case would be what we deal with in sexually violent predator cases that we pay for locally. And on occasion, those cases are pretty minimal when we have a respondent that does not contest the matter. But on the other hand, we've had expenses in these cases running well into the 5 digits. It's pretty inescapable that in terminating parental rights, due process is going to dictate that a responding party receive counsel at the expense of the government if necessary. And in addition, it's probably going to be pretty likely, especially if we have a case that has a long delay involved, that we're going to use a guardian ad litem in those cases to represent the interest of the child. I'm just suggesting that the legislature recognize that this is not just a local problem, but it's a statewide program, and that we take appropriate action to avoid yet another unfunded mandate on counties and the district courts. With that, I'm happy to answer any questions that you might have.
Judge, are there any other neutral conferees in the committee meeting room or online? Seeing and hearing none, then we will open it up for questions to our conferee. Yes, Senator Thompson.
Thank you, Madam Chair. Thank you, Judge. I think those are all good. I was reading over all of your written testimony, and glad that it sounds like you're already working with, going to work with the other folks on this issue. The only question I really had was with regard to Senator Haley's suggestion and your suggestion with regard to the staleness of evidence and that first concern. Would you have any suggestions as to the limitations of time on filing those, or is that something you feel like you could work with the proponents of this bill to come up with an acceptable number?
I would like to probably talk with the proponents of the bill a little bit about that, but just as a general matter, we have an overall statute of repose of 10 years that might be appropriate to consider if you're going to consider imposing some type of limitation period.
Okay, thank you. I think it's a good idea. All of these are great suggestions in the written testimony. Of course, there's always the money issue, but with the ad litem. But I think everything else would clean up the bill very nicely. Thank you, Madam Chair.
Thank you, Senator Haley.
Thank you, Madam Chair. Senator Thompson kind of asked my question, and certainly first let me say it's good to see you again, Judge Wheeler. Thank you so much for your ongoing advocacy and representation to not only the Judges Association, but to your district as well. It's good to see you again, sir. To follow up on Senator Thompson's question and my concern, and I know you'll be visiting with the advocates, as has been said, maybe we need to talk to a advisor. I'll be more comfortable with this bill, which in concept I completely support, Madam Chair and members, if it were in proximity, the reporting of the allegation of rape, prosecuted or not, were conveyed within some reasonable proximity of time. It's probably going to be before the birth of the child to make me comfortable. And so I don't know what the middle ground's going to be, but, you know, a sex act is a time certain, and from that point on, up to the age of the majority of the child, relationships can shift, perceptions can shift. You did share, Your Honor, that, you know, evidence stales. So while the very egregious act of a rape or did occur, I'd be more comfortable if before too much time elapses from that, probably before the birth of the child, that it would be conveyed, reported, potentially prosecuted. The exception for me, Judge and Madam Chair, would be, as was stated by the proponent, a child who herself is the victim of incest or would have some time period. I know we have that carved out in other areas of the law where there could be that period of grace, that grace period for the child to reach majority or what have you. But anyway, just my thoughts on that and about the proximity of notice of the allegation to be conveyed to a tribunal or third party or even a prosecutor. Thank you, Madam Chair.
Judge Wheeler, did you wish to respond?
Again, I'm going to take the position that that really is up to the wisdom of the legislature, and I think the proponents probably need to weigh in on this too. I think it would probably be pretty unrealistic to require that the action to terminate be filed prior to the birth of the child. There are far too many scenarios that in which the birth of a child follows some types of sexual assault to assume that a victim of sexual assault would even be thinking about this process before the birth of that child. There may be prosecutions ongoing. There may be continuing relationships between the parties. There's just too many variables as far as I'm concerned to limit it that closely. But at the same time, I think there has to be some sort of outer limit, but far more perhaps than what Senator Haley's suggesting.
Would any of the proponent conferees like to reply?
Gillian Chadwick, Judicial Council. Yes, I agree. I think when we start looking at cases, you know, and again, the trauma that a survivor goes through, it may take a while to realize one is pregnant, and then there can be a period of even denial of, you know, what happened, and all kinds of psychological trauma that's difficult to even really comprehend, you know, for those who haven't gone through it. And so I think, you know, I'm happy to work. My committee is meeting tomorrow, and I'm happy to discuss this with them. And I think I could see definitely, I think there is some opportunity for a middle ground. I mean, whether it's the 10-year idea that the judge put out, or, you know, with exceptions for maybe if there is a criminal conviction, there could be an exception, or if there's, you know, incest or the person's a minor, you know, there are situations where we need to really contemplate. It's not going to fit into people's expectations. I mean, there really is no, you know, there's no one way that victims respond to sexual assault. And so I think, you know, I'm very wary of a time limit of any kind, because I would just rather have judges looking on a case-by-case basis at that psychological issue for the child and looking at, you know, whether there are other factors that need to be considered, and allow it to be resolved in the courts, which is where we have to solve many messy family law issues. But I'm definitely open to discussing with the Judicial Council Family Law Committee the ideas that were put forth today and see if we can come up with a proposal.
Thank you. I did have a question for the Kansas Judicial Council Committee. There is a fiscal note in your committee folder, and we have from the Department for Children and Families states that enactment of SB 123 could result in more children entering foster care. Did the Kansas Judicial Council have any thoughts on that?
Well, again, I don't know that I would disagree with that statement, but I think when we think about the number of children, I mean, I did do like the back of the envelope math, which is if there are 8,000 to 16,000 women who become pregnant and choose to raise the child conceived from rape, you know, if Kansas's population is 2.9 million and the United States population is 380 some million, I mean, not saying that the distribution would necessarily be, you know, perfectly even across the country, but if it were, we're talking in the realm of like, I think 80 to 160 a year. And that's just total. That's not, I mean, some sex offenders are put away for life, and those survivors may not feel the need to engage with the court system any further and expose themselves to additional trauma. And then, you know, others may have different situations. So we're not talking about some thousands of children who are going to come into the system as a result of this. And again, whenever I talk about it being a small number, you know, I just think, but for that small number, it's an incredibly important issue, and it's enough people that we should care about the issue. But we're not, I don't think we're talking about like such a strain on the system.
Senator, this is Judge Wheeler again. At the risk of becoming a bit of a proponent for the bill, I would consider that fiscal note to be so minimal as to be of little concern.
Thank you. And I wasn't so concerned about the fiscal note, but just the statement that the Department for Children and Families states that enactment could result in more children entering foster care.
If I can just address that again, I mean, I think what will most likely happen is that this will result in women not having to cope with their rapists. There may be, anytime the state becomes involved in a family, there is a small number of those cases that result in the state becoming involved in terms of you know, DCF becoming involved in the parenting, but that goes to first, you know, a unification plan that has, you know, steps that parents need to take. So for example, if the mother is suffering with, you know, some issue that needs to be addressed, then there are services that would be provided long before someone would come into foster care. So I revised my previous comment to say that, you know, even within the small number of people that we're talking about, I agree with the judge. This is sort of like more of a theoretical possibility than something that's really going to happen in more than just the most extreme and rare cases, I think. You know, the purpose of the bill and the way it's written is to support the parental rights of the mother so that then there's no further interference. You know, I mean, frankly, yeah, I think the idea of state involvement or kids going into foster care is just, it's pretty marginal.
Senator, I perhaps didn't make myself clear. This is Judge Wheeler again. If I thought that there was going to be a dramatic growth in child in need of care cases and children coming into foster care as a result of the passage of this bill, I'd be the first one to tell you. I just don't see that as a possibility that would raise a significant concern.
Sure, great. And thank you both for clarifying that. I did just want to you know, look at what the Division of the Budget has provided to the committee, and that statement in there did cause some pause. So I'm glad we had clarification around that. So with that, I will direct the committee in your committee folder. There was also neutral conferee written testimony from Christina Silva Office of Judicial Administration. And do we have any other committee member questions for any of our conferees? Seeing none, then I will thank the conferees. And Judge, thank you for appearing, as well as Ms. Chadwick and Ms. Rust Martin. And thank you for your thoughtful testimony and answering questions. And with that, then we will close the hearing on Senate Bill 123. And committee, we do have some time left, and I'd like to work a couple of bills that we heard earlier this week. One of them, if you'll pull out your folder for Senate Bill 103. If we could have the reviser kind of remind the committee with a bill brief about the contents of Senate Bill 103, that would be great.
Thank you, Madam Chair. This is Jason Thompson with the Reviser's Office. You will recall that Senate Bill 103 is the Power of Attorney Act amendments that were brought to you by the Judicial Council. This is the bill that was House Bill 2500 last year. It had several amendments made, further amendments considered in your committee, and this bill includes all of those amendments that were considered last year. It makes various changes to power of attorney that is executed on or after July 1st of 2021 about being in substantial compliance with forms set forth by the Judicial Council. It also has some amendments relating to third persons being exempted from liability when they rely on a power of attorney that's presented to them. And finally, it has some provisions about what happens when a third person refuses to accept a valid power of attorney and what can be done in court about that.
Thank you, committee. Are there any questions for the reviser? Seeing none, then, is there any discussion on Senate Bill 103? Are there any motions to entertain on Senate Bill 103? Senator Thompson?
Yeah, I move we report favorably. I don't think this was amended, was it? Report Senate Bill 103 out favorably for passage. Madam Chair.
Is there a second? Senator Corson? Discussion on the motion? Seeing none, then we'll vote on the motion. All those in favor say aye. All those opposed, nay. The motion carries. Committee, then we will next look at Senate Bill 107 and work Senate Bill 107. That again was a bill that we heard earlier this week. And if we could have a bill brief on Senate Bill 107 from the reviser, Mr. Thompson.
Thank you again, Madam Chair. Jason Thompson with the Reviser's Office again. Senate Bill 107 is the slightly long bill that enacts the Uniform Fiduciary Income and Principal Act and repeals the Uniform Principal and Income Act of 1997. You heard testimony about, again, from the Judicial Council about adopting this Uniform Act to replace the one we adopted years ago. And it primarily deals with allocating income and principal and how that is done inside this Uniform Act.
Thank you, Mr. Thompson. Committee, any questions for the reviser? Yes, Senator Corson.
I had a note about this was HB 2554. Can you just remind us what happened? I believe this was heard last session, but can you just refresh my recollection on that?
Thank you, Mr. Thompson.
Yes, thank you, Madam Chair, and I apologize. I should have mentioned that like I did on the prior bill. Yes, House Bill 2554 last session was requested by the Judicial Council, passed the House 125-0, and had a hearing in Senate Judiciary, but was not able to be worked due to the early end of the session.
Was 125 to 0. Any other questions for the revisor? Seeing none then, any discussion on Senate Bill 107? Yes, go ahead, Senator Thompson.
I move that we report Senate Bill 107 out favorably for passage.
Thank you. Is there a second? Senator Corson. Any discussion on the motion? All right, seeing none then, we'll vote on the motion. All those in favor signify by aye, please. All those opposed, nay. The motion carries. This is one that, though it looks like, well, it did pass the House unanimously last time. It was not heard on the floor in the Senate, so I think we need to keep this and run it across the floor and not place it on the consent calendar. I think that's a good policy. Thank you, committee. What's the committee's will? We were looking at possibly working today Senate Bill 60 regarding when a bad actor is outside the state of Kansas and the harm of their actions is their criminal victim is here in Kansas, that this would allow prosecution of a person outside the state of Kansas when the act occurs there, but the victim is, the harm is done here in Kansas. It's 11:34. We do have some time to work this, so I'd like to go ahead and work this with the time that we have left. So if we could have a bill brief then regarding Senate Bill 60 from Mr. Thompson.
Thank you again, Madam Chair. Jason Thompson with the Revisor's Office. Yes, Senate Bill 60 is a bill brought to you by the Attorney General's Office. It would define proximate result for purposes of determining when a crime is committed partly within this state. And as your brief refresher on criminal jurisdiction in Kansas, KSA 21-5106 is the statute that controls jurisdictional application. It's the section amended in the bill. There are many ways you are subjected to jurisdiction in Kansas, but one of the ways is if you commit a crime wholly or partly within this state. And furthermore, one of the ways you can commit a crime wholly or partly within the state is if the proximate result of such act occurs within this state. And so the bill is defining that term, proximate result, as any logical effect or consequence of such act, regardless of whether the statute governing the charged offense considers the specific effect or consequence of such act. And you heard this was in response partially or almost completely maybe to a Kansas Court of Appeals decision that is being reviewed by the Kansas Supreme Court, but is still pending, where they said a particular effect of an act was not contemplated by the statute, and so that act could not be punished under a criminal statute. So the response in this bill is to broaden the definition of proximate result to encompass any sort of reasonable result of your action. I'll stand for questions if you have any.
Thank you. Any questions for the revisor? And committee, if you'll remember, yes, Senator Pyle.
Jason, I guess I'm curious, when I read the testimony in support of that we had from the AG's office, it says in order to prevent out-of-state actors. How is this going to prevent that, those actions? And what's the punishment?
Mr. Thompson, if you have a response.
Madam Chair, if I heard all of the question correctly, it was just if there's a punishment or how it would prevent. I think the argument that the AG was making, and I can't really make it for them exactly, but I think what they were trying to say is they view this, the restrictions on proximate result imposed by the court's recent opinion, they view that restriction as making it difficult to prosecute crimes that only occur partially in this state and for remote actors. And so this allows them to at least get to the jurisdiction part where they can say, you committed this act, it had this proximate result in our state, and so we can prosecute you for whatever the crime was. In the case, it was insurance fraud, but it could be identity, or it could be any number of crimes that could be committed remotely. And so I think their point was they view this as a hindrance to their ability to prosecute, and the change would help them to prosecute. I think you also heard from the other side that, you know, some folks don't think that it's quite as big of a hindrance as you might be led to believe. So I don't want to play up one side over the other. I'm trying to stay in the middle here.
Senator Pyle.
Yeah, that's, what I see that, I mean, this is somewhat feel-good legislation. I don't see how it prevents, you know, unless, if they're not in the state, yeah, it does give some jurisdiction to saying that, okay, they committed a crime, they're out of state, but I guess I don't see any, what's the enforcement, how do you prevent, their words were prevent out-of-state actors. I guess I don't see the prevention here, and, you know, what consequence to someone that's a foreigner that's doing claims, fraudulent, whatever the action is. I guess I'm just, I'm trying to see what the teeth in this legislation is. And if the reviser can clarify that for me, I'd really appreciate that.
Mr. Thompson, if you're able.
Madam Chair, I don't know that I have much in the way of response to Senator Pyle's issue with the bill. It's not aimed at being able to go out and find the person or pick the person up. It's more of a, we know who the person is, we want to charge them, and this gives jurisdiction to charge them. But you still have all the practical problems you have with charging any criminal defendant, being able to locate them, you know, extradite them, even in this case. And so I don't know that I have any way to address the point. It's a question that he raises, and I guess I don't have anything more I can say. Sorry.
Thank you, Jason. And I'm not in opposition to this. I just don't see that the bill goes far enough to where we can actually do something once we know. So anyway, thank you. Thank you, Madam Chair.
And to address some of those concerns, you know, no statute like this is going to prevent, but it is a tool that our law enforcement can use, that when the bad activity is discovered, we have an ability to prosecute it here. So I saw a couple of hands. I'll take them in order. Senator Gossage.
Thank you, Madam Chair. I'm looking at the opposition that was brought up, which was from the Kansas Association of Criminal Defense Lawyers. And basically, my questions are regarding that they say SB 60 is unnecessary. And they said they don't know who proposed this particular bill. And they also mentioned that it could result in unintended consequences. And they're referencing a Roselle case that person could have been prosecuted in Missouri since it was done outside of the state. So I don't think that I'm ready to vote favorably on this unless somebody else on the committee can enlighten me.
I think the bill came to us from the Office of the Attorney General as another tool to prosecute. We heard a lot about the unemployment fraud that was happening in Kansas, fraudulent claims being filed against Kansans here, if you recall some of that testimony, and this would be a tool that the state of Kansas could use to prosecute those bad actors who are unfortunately filing fraudulent unemployment claims. Okay, great. Senator Corson, you had your hand up. Do you have a question?
No, Madam Chair, you actually made the same comment I was going to make, much more artfully than I was going to make it, so I appreciated it, so thank you.
Thank you, Senator. Senator Wilborn.
Thank you, Madam Chair, and this question is for the reviser again. Correct me if I'm wrong, but actually the penalties would be dependent upon what crime was committed. That's the reason there's no reference to penalties in this statute. Am I correct?
Mr. Thompson?
Yes, Madam Chair, this is Jason Thompson again. And thank you to the last couple for speaking really into the mic today. We're having a lot of trouble picking it up, so thank you. Yes, the penalties would be as provided by the particular crime. So as the Attorney General said in their testimony, Roselle was about an insurance fraud case, so they were trying to charge under that specific crime, and the court said that crime does not contemplate this proximate result that you are saying happened, therefore you can't have jurisdiction over them for this crime. And so if the crime they were trying to charge had been identity fraud or some other crime, they would have looked to that statute to see if it had this proximate result contemplated or not. And so it's dependent on the crime and dependent on the penalty in there, as you said. And one of the suggestions in the opponent testimony that was just referenced a moment ago was that depending on the crime, we could go to the crime and actually define the proximate results that you, as a legislature, intend to be punished. But the AG has suggested to you the broader approach in the bill of any sort of logical consequence being a proximate result. That's the policy option they're asking you to consider. But the other option would be to go into these crimes that can be committed out of state and to define the proximate result that you're concerned about. Obviously, a little more painstaking and a little more detailed, but it is an option. So I didn't want that to be overlooked.
Thank you.
Thank you. Committee, any other questions for the reviser? Or any discussion on Senate Bill 60? Yes, Senator Baumgardner.
Madam Chair, I make a motion that we pass out Senate Bill 60 favorably.
And we have a second. Is there discussion on the motion? Yes, Senator Haley.
Madam Chair, I have an amendment. I didn't know that we were concluding all the discussion for the background of the bill, but I have prepared an amendment for consideration by the committee.
Senator Baumgartner, do you want to, and Senator Gossage, withdraw your motion, or is that a substitute motion, Senator Haley?
Well, I could make the substitute motion. I did not know that there was all the discussion that had been done beyond the reviser's review. So I guess then if a substitute motion would then be in order for consideration of the draft amendment, then that's what I would do.
Mr. Reviser, if you can help us with the process here. We have a motion and a second already on passing the bill out favorably from committee, and there's been made a substitute motion. I haven't asked for a second yet on the substitute motion, but would the substitute motion be in order at this point to be seconded?
Madam Chair, this is Jason with the reviser's office. As usual, I'll begin by saying it's the ruling of the chair will control here. Generally speaking, if you have a motion on the floor, their substitute motion would be in order, and you can either have the motion withdrawn and have the motion to amend be taken up, or you can have the substitute motion to amend and handle it that way. But it's up to the chair's discretion.
Thank you. I will ask, we have before us, committee, a motion and a second to pass the bill out favorably. It was then presented that there is a substitute motion to discuss an amendment. I guess I'll first ask, do we have a second for the substitute motion? And we have a second then for the substitute motion. Let's have discussion then on the substitute motion before we vote on it. If Senator Haley.
Thank you for the consideration. It'll be brief, Madam Chair, if I can distribute the amendment to the underlying bill. These.
Mr. Reviser, correct me if I'm wrong on the process. We have a substitute motion and a second. Do we need to vote on the motion before we actually hear the amendment?
Madam Chair, Jason Thompson again. If you were to follow the typical Senate floor procedure, you would have the motion offered, explained, then see if there's a second, then move to discussion and working the amendment. That would be the typical procedure.
So is discussion on the motion, the substitute motion, in order? Mr. Thompson? Yes, all right.
Madam Chair, since you've allowed the substitute motion, you are now allowing discussion, and that would be in order.
All right, Senator Haley, do you want to explain your motion, or excuse me, your amendment?
Yes, and thank you for the court, for the chair's indulgence, and for that. Again, procedurally, this is uncustomary that we would not engage in whatever additional considerations we have for the underlying bill from any member of the committee. But that being as it is, before us we've had the discussion as to when our laws are broken or a law is broken in another state, and what occurs in our state. What this amendment does is very simply this. And anyone who has purchased legally marijuana in another state but happens to be passing through our state could not be held as for committing a crime. That is essentially what it does.
Point of order, Madam Chair.
Yes, Senator Pyle.
Madam Chair, I know that he's explaining, but I seconded the motion, and it appears to me that this is not germane to this bill, so I'm challenging the germaneness, Madam Chair, and you'll have to rule on that, please.
Yes, thank you, Senator Pyle. I've reviewed the amendment for germaneness, and what the bill does is it concerns acts outside of the state that have a victim here in the state. What the amendment proposes is an act, a crime that occurs wholly within this state, and it's not the intent of the bill, and it's also I believe then it also references chapters of the Kansas statutes annotated that are not within Senate Bill 60 as presented to us. So I'm finding that it is not germane to Senate Bill 60, and I'm going to then rule that the substitute motion, is the process, Mr. Revisor, correct, that the substitute motion fails?
Madam Chair, Jason again, Jason Thompson. If you're following the typical procedure of you've ruled that the motion is not germane or the amendment is not germane, then on the floor it would be subject to a challenge of the ruling of the chair or the issue is separate.
Well, the ruling is that the amendment is not germane to the bill. With that, then,
Madam Chair?
yes, Senator Haley, do you have a question?
At this time, Madam Chair, I will not challenge your ruling. We'll be, of course, saying that this has been carefully vetted, though. I rely upon the insight of those in our advisor's office, but I will not challenge it for the sake of time. But I do hope the issue will be taken up again very soon, perhaps if it runs on the floor.
Thank you, Senator. Is a vote then on the substitute motion in order, Mr. Thompson? Or the amendment is not germane and we're not going to then vote on the substitute motion, so we were back on the original motion that the bill be reported out favorably. We have a second. So is there any further discussion on the motion before us? Seeing none, then we will vote on the motion to report the Senate Bill 60 out favorably for passage. All those in favor say aye, please. Those opposed, nay. The motion carries. With that, committee, then, we are concluding our agenda for today. We do not have a meeting scheduled for tomorrow, so I appreciate the work we did today, and we are adjourned.